Good morning, everyone. And good morning, Mr. Chief Justice. Thank you for taking time out of your schedule to come and talk to us about the changes that are taking place in Tennessee and for your leadership on indigent defense issues.
Good morning. Very happy to be with you. It's a very important issue to us, and I think we've learned a lot and are still learning a lot more, and hope to do so through being here today as well.
Wonderful. The changes that are being worked on in Tennessee really got started back in September 2015 when then Chief Justice Sharon Lee stated in a press statement announcing the creation of an indigent defense task force that when it came to indigent defense in Tennessee, that it was time that Tennessee needed a better mousetrap. Echoing something that I heard Director Blue say on the earlier panel, she continued, "We just can't keep doing the same thing and hoping for a different result." So with that, can you explain to the people here what the systemic right to counsel issues were that the court felt needed addressing and why?
I'd be happy to. Yes, we really have almost three independent systems or components of our indigent representation system in Tennessee. That being, number one, we do have local elected public defenders. There are 31 judicial districts in Tennessee. Each district has an elected public defender and staff for that, but they function at the local level. Then we also have private counsel that is appointed when there are conflicts or in other instances of when the public defender cannot provide that representation. The elected public defenders are woefully underfunded, quite frankly, but I mean, from the standpoint of their caseload. They have an incredibly high caseload. They're only handling about 17% of the delinquency matters in juvenile court now as a result of the lack of funding that's there. Then from the private counsel standpoint, Tennessee ranks 49th right now in the pay for private counsel. We've not changed our compensation in 20 years. And currently that compensation is $40 for out-of-court work per hour and $50 for in-court work. As I've told a number of folks, I said I don't mean to insult the folks that come repair things at my home, but when's the last time you had a repairman at your home and paid only $50 an hour? But that's what we're paying our attorneys in Tennessee. And obviously it affects the quality of the representation that occurs there. The third component of it is a fairly minor component, but another siloed portion of that is our post-conviction defenders. And they are essentially relegated to handling post-conviction capital case matters at this point. So anyway, all three of those have their own problems, but together it's even a bigger problem, and we recognize that reforms are needed. So we as a court decided it was time for us to step up and try to do something and bring that to a head.
Great. And just before we get down to too many details, just overall as a sitting Supreme Court justice, why does the right to counsel matter to an effective and efficient justice system?
Well, I think two things come to mind. Number one is from the overall overreaching side of it, we take an oath to uphold the Constitution. And just like we've heard here already today, the Constitution guarantees a right to counsel and to be represented. So we, as justices, have an obligation to enforce that and make sure that that happens. And secondly, from a more practical side and a better side, it's advantageous to both the victims and the defendants to try these cases one time. We need to get it right the first time. We need to make sure there's adequate representation from the beginning so we don't have the cases reversed 5 years down the line and then have to go back and the victims have to go through another trial all over again.
Great. Now the court opted to approach these issues through a task force model, and it's certainly an approach to reform that I've seen work in as diverse places as Utah and Idaho and Michigan. But why in Tennessee did the court think this was the approach, and can you describe the background of the people that were appointed and why?
Sure. Well, as you can imagine, the indigent representation system, any type of reform from that standpoint is going to take work not only from the judiciary but also from the legislative branch and the executive branch. we can do some things, but we can't do it all without assistance from that. Plus the fact that even part of what we can do, if we do it in what's perceived to be a heavy-handed manner, we probably are going to run into more roadblocks than we would otherwise. So we felt that establishment of a broad-based task force was the better approach to go here. And what we did was reached out to those other branches. And for example, the governor's top legal counsel was a member of the commission. We had the chairman of the Criminal Justice Committee of the House of Representatives as a member of the task force. We had a member from the Senate Judiciary Committee as a member of the task force. Then we had a number of well-respected private lawyers that were there. We had judges there, trial courts, even our lower court level, which are called general sessions courts, to trial courts, all there have a stake in this and to be a part of the solution. We added, as I say, put the private lawyers, academics, and other folks. What we did not do were have active prosecutors or active defenders on the task force. We felt it was better at that point to allow them to present to us and give and advocate their positions to us, as opposed to having them as actual members of the commission. And lastly, very important part of it was choosing the right person to be the chair of that commission. And what we did is looked around, and in fact, it turned out to be the former justice on our court, whose position I took when I came on the court in 2014, who is now the dean of one of our law schools in our state. And Bill Koch, Dean Bill Koch, is one of the most well-respected jurists in our state. He's well-respected by the legislature. He's well-respected by the executive branch. He has a history of serving as legal counsel to the governor. He had served in our Attorney General's office, and of course on our court and at the Court of Appeals for a number of years. So he was the right person at the right time. And I think, David, you got exposed to how
I did.
what a detailed person he is, and what an incredible asset he was throughout that entire process.
Yes, sometimes the Sixth Amendment reports can be lengthy, and when we sent materials to Dean Koch, he'd always call back and say, now on page 65, there's a footnote that I need further explanation on.
The man reads everything.
And I did have the pleasure of testifying before the task force and later on providing technical assistance with the assistance of the Department of Justice to the task force as they drafted their report. And I agree, I don't think there could have been a more serious group of people to put together. I think it was, again, without coordinating with the Contra Costa panel, this idea of bringing diverse people together to look at these issues was really beneficial. So with that, can you explain what it was exactly that the task force found after their year of work?
Well, one of the primary things the task force came back and recommended was that we do away with the silo approach of having these different systems, and we try to coordinate that through one group. And the best way to do that, in their opinion, which we agree with, is the establishment of an independent commission. And for that commission to oversee a number of the areas, such as a single annual budget for all of those entities, both from the juvenile side and the adult side, uniform training, uniform certification of lawyers that participate as the private lawyers. Right now, we have no certification process whatsoever for the private lawyers that take place there. The CLE that's needed on an annual basis for the lawyers. And also then part of the administrative side of that's now being handled by our administrative office of the courts would be transferred over to that commission for the administrative functions for more efficiency from that standpoint. In addition to that, the task force also made some additional recommendations, such as the creation of an appellate division for the public defender's office. Currently in Tennessee, the local district attorney's office handles matters on the prosecution side at trial. But then the state attorney general's office takes over on appeals. So they have a separate appellate division there that handles all the appeals. Unlike that way, in the public defender's office, the local public defenders continue on many times to represent the defendants at the appellate level now. And as we all know, oftentimes good trial lawyers are not necessarily good appellate lawyers, not because of any failures, but simply because of the different skills that are involved. So we feel like it's very important to establish a statewide appellate division where all appeals that are handled by public defenders' offices are handled by trained appellate lawyers. Another aspect of it is to increase the funding for the public defender's office. As I said, they're already understaffed. Hopefully getting the appeals process off of them will help to a certain extent anyway. But in addition to that, we want to make sure that the legislature provides funding to where they can pick up on those juvenile delinquency cases we were talking about and doing that. Another aspect of the recommendations was creation of a conflicts division. So in those cases in which the public defender's office has a conflict, for example, in multiple defendant cases, the thought being that if you have a separate division, there can still be a public defender, therefore with fixed costs, that can handle those more than one defendant in a multiple defendant case, ultimately resulting in fewer private counsel appointed and cost savings to the state through that. And finally, one of the big recommendations was with regard to the hourly rates being paid to that private counsel. The task force came up with recommendations saying that they felt that the proper rates were somewhere between $75 per hour and $125 per hour as their recommendations.
Great. And then we all know that oftentimes reports come out and they can go right on a shelf and collect dust, but things are moving in Tennessee. What was the process once the court received the task force report, and where are things right now?
One of the things we tried to do very openly and very carefully throughout the entire process was for the court to keep somewhat of a distance from the commission, because we wanted folks to understand this was not the court's report, this was the task force report, and it was important to us to have that independence that was there. So once, obviously, we kept informed along the way and participated and watched, but it was important to be an independent recommendation. Therefore, once we got the report, a very comprehensive report, we took it, studied it for a good length of time, and developed our own plan of action. And as David stated, that oftentimes in the past there have been efforts that kind of will start a little bit, but then they'll be thrown on the shelf. And we did face a lot of that. People were saying, well, so what if you get a report? Nothing's going to happen. Well, I hope that they now see that's not true, because we as a court now have affirmatively put out a press release and have affirmatively made requests for our budget for next year to start the implementation of these recommendations. And in fact, one of the main things we're doing this year was we're requesting as the first step to take the rate of pay from $40 and $50 an hour to a flat $65 per hour rate for the private counsel. In addition to that, not only do we have the low rates, we have caps on each case as well, oftentimes anywhere from $1,000 to $2,000 per case. So it's a catch-22 as far as the compensation goes. So in addition to the $65 per hour, we're also asking for an increase in the caps of all felony cases of $500 per case, and an increase in all juvenile cases of $250 per case. So that total amount is a $20 million ask that we have put in our budget for this year. And in fact, we've already had meetings with the governor, with the governor's finance administration commissioner. Governor's legal counsel is very much behind us on this. So, and I've asked for a private audience with the governor on it. So we are very much committed to moving forward on that. Additionally, we are supportive of creating the commission, and we're going to move forward with that. We want to we've adopted the recommendation regarding the appellate division. We've adopted the recommendation regarding the conflicts division. So we're in the process of starting to implement these things. We recognize that it can't be something that can be done overnight. Again, some of this we can do ourselves, but some of it has to be done in partnership with the other branches. And if we do some of what we do or could do in a heavy-handed manner, we're going to run into problems as we go. So we feel like this approach of trying to pull everybody on board is the approach that will be most successful as we go along.
And just so everyone knows, when the Chief Justice talks about a $20 million increase, the right to counsel spending in Tennessee right now is about $98 million. So you're talking about a significant 20% increase in the funding for the right to counsel. Now, you've talked about the support of the court, and we all know the legislative process is its own animal. But if you could sort of project where you think this is going on that next step, even though it may take some time.
Yeah, I think we've received good reception from the legislative folks so far. I think we're going to get everything we want in this session? No, probably not. But it's time to begin that process. And for example, the creation of the commission is one of the things which we're going to advocate and propose as a legislative matter, this coming solution. Do we get that this year? Quite frankly, I'm not sure we will. But we're not going to get there until we start. And it will be a multi-year prospect. But from the standpoint of the funding, we're very fortunate in Tennessee right now. Our budget is very good. We're not going to be as good as we were last year, but last year, for example, we had $900 million in excess for recurring funds and $900 million in one-time funds. The state economy is doing that well. We're still doing reasonably well, but not nearly to that level. But as long as that continues, I think our funding request has a real opportunity to do that. So as I say, we're already in the process of meeting individually with legislators. We're in the process of working with the governor's office, because getting it in the governor's budget will be a huge deal. In Tennessee, if it's included in the governor's budget, it's very likely to pass. It becomes much more difficult if it doesn't get there. And the Commissioner of Finance Administration, after we talked to him, one of the things I said to him is, this is not a Republican issue, this is not a Democratic issue, it's the right thing to do. And he mimicked that language to us before we left that meeting. So I think he really gets it, and I know the legal counsel does. So I'm optimistic that we're beginning to make some real progress there, but it will be definitely a multi-year effort.
Now, nationally, we've seen both these sort of task force approaches, but also litigation approaches. We know the ACLU is in California and Utah and Idaho and various other places. Do you have thoughts on sort of the approach that's been taken in Tennessee? And I know you've had your own sort of brush with some litigation as well.
We have, although our court wasn't directly involved, there is a situation in Shelby County, which is the Memphis area, in which the Department of Justice came in a few years ago investigating the juvenile justice system there in Shelby County, and it ended up entering into an MOU to address concerns there and to try to implement some reforms in that system. So we have seen some aspects of that. But just like other states, I think we are concerned, and certainly don't feel like that litigation is the way to resolve this issue. But in all likelihood, quite frankly, as I've told legislators and members of the executive branch, if we don't do something, we may well be facing that litigation in Tennessee as well. And why not get out in front of this? Why not address it? Number one, it is the right thing to do, again, but number two, ultimately it's going to be much less expensive than litigating hundreds of thousands of dollars in federal court over whether we have an adequate representation system or not. So we're really advocating that, and pointing out that that there are conservative groups very strongly behind this as well as liberal groups. It's not a partisan issue. So this is the time to bring everybody to the table. Let's work on a solution that everybody can live with, and let's have a better indigent representation system in Tennessee.
Great. Thank you very much. I don't know if we wanted to entertain questions, but we did leave 5 minutes just for that if anyone does have questions. We solved everything.
That's it, exactly.
So, yes, Scott.
The issue of accountability for private counsel. You're asking for additional funds. I guess, to what extent are you expecting that just to, result in better representation because maybe better lawyers will come into the system for better pay? Is that the anticipation, or will there be, other additional not safeguards, but oversight or attempts to
first of all, I think hopefully it will help on the initial end of getting better quality and getting more experienced lawyers back into that area who have left because of that. But secondly, more importantly, that's one of the big things that the commission would focus on, and that is establishing those credentials, making sure that there is accountability, making sure there is training, and holding those private counsel accountable as well. That would be one of the charges given to the independent commission that's established.
Yes, sir.
With respect to the $500 cap that you mentioned on felonies, is that, with respect to the $500 cap you mentioned on felonies, is that something judges can award fees in excess? Because that strikes me as extremely low for a felony.
Well, actually, the caps are anywhere from about $1,000 to $2,500. We're talking about raising them by $500 for each one. But the answer to your question is there is a limited ability to do that. Cases can be declared complex if they are, and the caps double in that instance. But also in first-degree murder cases, if they're certified as complex, then the caps come off in that instance. But it's only a very limited manner in which the judges can do anything about it at this point. So.
Yes, Paul.
The $20 million that David referenced that you're proposing to be added to the budget, does that include the creation of an appellate division as well as the additional money for assigned counsel and additional funding for the local public defender?
It does not. That's separate and apart. Those are going to be different requests that we'll probably come back with the following year. The $20 million is solely the cost of the increase in the hourly rate and the raising of the caps.
Was there a fiscal note on the task force report altogether?
There has not been on that. We have different components of it, but we've kind of intentionally not put one on it.
Paul, they're estimating that the appellate unit would probably be 20 attorneys over 3 offices, east, central, and west. So you can sort of get a gauge of whether that's going. And then there's just some more work to be done on estimating what the cost of expanding public defenders and the commission would be, that we wanted to get this first ask off the table to do that. Great. Well, thank you all.
Thank you.